We've done this before. We are
Not
pleading
with
no.
me.
Actually, I have on one prior plea. We can't stipulate to the amount, so we would have at the very
That's why
least.
you have it. Nobody ever stipulates to an amount. That's why you all have contested hearings and I make a decision on whether or not they owe it or not. And then if need be, if you need to call me as a witness, I will come as a witness if they refile it.
I'm asking for the court to not order restitution to the third parties. I don't think that that's appropriate.
Well,
They
that's
have-
where you present evidence and I make a decision, or you present some kind of law and I make a decision on whether or not.
The state,
Okay, I'll have you all come back at 1:30. Who's next?
1:30.
Who's next?
I can't come back at 1:30.
All right, James Francis.
I'm not supposed to be practicing law, so I don't feel that I should have to go forward. Yeah, I just wanted the court to be aware that my processing right now is slower. I was being careful.
No, it doesn't, Pam. The
Driving.
fact that you were in an accident in the past on a different road has no bearing on what's happening here.
Does because
Thank you for dressing appropriately for court. I really appreciate that. All right, and sorry about the mispronunciation of your first name. It cut it off on the docket, so I didn't see it all.
Been called a lot of things.
Hi. All right, so where are we on discovery?
Judge, we conferred a little bit about it this morning. There are some issues that Ms. Corley's brought to my attention that stuff that I believe we have that I'm not sure if we turned over. So I'm in the process of making sure that we've gotten everything that she's supposed to get to her. Additionally, there's some issues that have been identified with the evidence that I'm hoping to resolve and hopefully eventually get this resolved with plea, but it's going to take a little bit of time for me. I might have to have some subpoenas issued to get some bank records. It is a mishap. It's fairly voluminous. I'm not sure if Ms. Corley's even had an opportunity to go through everything at this point. So I'd be asking for a 45-day reset and maybe keep us on the conferring docket. And I think we'll be able to get this worked out.
All right, so let me ask you guys this. So the discovery that's outstanding, you all think are some bank records?
There's numerous things, Judge. There's bank records, credit card statements. There's the credit card receipts, the signed receipts, things like that.
Okay.
And then other information about meetings and things that might be going on that some of this might have gone through. I have gone through, I just got the discovery the day before yesterday. And so I've tried to go through it, but there's one file that had 1,000 pages. There's two files that have 1,000 pages, and there's a lot.
Okay.
But I've given a list of the things that I've identified so far to Chandler, and he's going to be working on that for us.
Okay, I just like to have an idea of what discovery is outstanding so that there can be movement towards obtaining the discovery.
Yes,
So
ma'am.
you all are saying potentially bank records, some credit card statements and receipts and meetings.
Meetings and some other various things.
All right, and when you say meetings,
Minutes.
oh,
Well, there also a meetings calendar, so we'll know when these meetings took place, events calendars, holiday calendar events, those kind of things.
okay, meetings calendar.
And this is spread out over a number of years, Judge.
All right, and then when you say minutes, do you mean minutes from a meeting?
That's correct.
Okay, all right, now I know what I'm dealing with. That helps. All right,
And Judge, there may be additional things as I get things. I may have other things that I need to request, but
okay,
we are actively working on it, Judge. It's not sitting on a back burner.
all right. Ms. Ferguson?
Yeah.
And this is going to be your final discovery date.
Okay.
If I can have a 60-day reset for discovery.
Yes.
So that's your final, you all asked for 45. I give you a little bit more.
Better than before.
All right.
Thank you, Judge.
All right, the court is calling 2024 CR 011624 State versus Jan Hawkins, AKA Jan Madura. Can I have parties announce?
Chandler Bowen for the state of Texas.
Linda Corley for Ms. Madura.
And are you Miss Madura?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Off the record for a moment. So they have her AKA is Jan Madura, but that's her name, correct?
The case was originally submitted as Jan Hawkins.
Okay, but shouldn't Jan Hawkins be the AKA and not Jan Madura?
I think as long as they're both
both there, it's okay, is my understanding.
Okay. Because all of the other paperwork doesn't have an AKA listed.
We don't have any objection to that, Judge.
All right, we're back on the record. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
And are you Jan Madera?
Yes, Your Honor.
All right. And you're not Jan Hawkins, correct?
No, Your Honor, I'm Deanne Madera.
Thank you. Plea, the state is proceeding on the lesser included offense under count 2 of theft, $750 to $2,500. They're waiving count 1. They are recommending deferred adjudication. They say that you've paid $1,077.01 to the Junior League of San Antonio. And I'm assuming there are no other outstanding restitutions.
There's one that we've got on there below the line, Your Honor. There was an insurance claim that was made by the complainant by Berkshire Hathaway. It's reflected at towards the bottom.
All right, but there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations.
Your Honor, if I may, we did make an amendment to the stipulations in concert for agreement with the ADA. We have marked out we're not saying that all the stipulations are true and correct. We have a controversy on the amount, the final amount. So
I think the issue, Judge, is that if you're intending to impose the restitution to Berkshire Hathaway and Visa, they're going to ask for a restitution hearing. Is the main issue here.
Well, I am going to ask to a restitution hearing.
Okay.
And the fact, these stipulations, you can't just cross out that you're not stipulating that the evidence is true and correct because you haven't stipulated which party you're saying is not correct. When you cross out the stipulations, then you're saying we're not stipulating to any of it. So y'all will have to correct your paperwork.
Judge, if I may,
Mhm.
We've done this before. We are
Not
pleading
with
no.
me.
Actually, I have on one prior plea, on a case that was a family violence case, Judge, in this court. But we are pleading no contest, which means we don't necessarily agree, but we're not fighting about it, which is provided in the law for that purpose, having us we've also marked out judicial confession and changed it to no contest.
Oh, you can change all of that to no contest, but you can't change what you're stipulating to, because otherwise she's not even stipulating to the fact that she owed $1,000 to the Junior League.
Well, Judge, she doesn't have to stipulate to it. No, she's pleading no contest. And so that is the plea that's provided in order for people who disagree with what's being said to be able to move forward with a plea. I've never had a problem with that before. I've done it in this court.
No, I tell you what has been done. There has been, with regards to the indictment that's a part of it, where you say, I am not contesting anything, and you take out the judicial confession, but the evidence is the evidence that is presented. And then the court makes a ruling on whether or not that evidence is sufficient. But if you're saying we're not stipulating to the evidence that is being presented to the court, then she's not even stipulating to the fact that she's alleged to have committed a theft from the Junior League.
I think we've got a clean copy of the paperwork, Judge, that we can.
All right.
Judge,
swap out.
if I may, we can't stipulate to the amount. So we would have at the very
That's why
least.
you have it. Nobody ever stipulates to an amount. That's why you all have contested hearings, and I make a decision on whether or not they owe it or not.
And Judge, and I know we're getting in sort of ahead of ourselves, but I'm asking for the court to not order restitution to the third parties. I don't think that that's appropriate.
Well,
They
that's
have-
where you present evidence and I make a decision, or you present some kind of law and I make a decision on whether or not that amount that is below the line, because it's not a part of your agreement, then I make a decision on whether or not that amount should be paid or any amount should be paid to Visa or Berkshire.
And Your Honor, it's what I'm requesting the court to do is to not order that, so that can be handled in a civil court. They are set up for that. That's the way the normal course goes on these things, and it's going to be we would need a forensic accountant to go through this. It's going to be a very long and arduous restitution.
I understand what everybody is saying. I want to let everybody know I'm internalizing what's being said. What I am telling the parties is this. If she's not stipulating to the evidence that's been presented by the state, that means she's not stipulating that she even committed a theft with the junior league. I don't know why she paid the amount to the junior league because she's not stipulating to that. Things that are below the line, that means that it's contested. That means that I'll hear evidence. I'll make a decision on whether or not restitution should be paid to Berkshire or Visa. That's something that I will hear. The only thing you're allowed to do, I don't contest, is when they have in the plea paperwork where it has the indictment on or about whatever, that's like on or about whatever I judicially admit. You can scratch that out and you put, I'm not contesting anything. But for the stipulated evidence, the evidence is what's being presented. Otherwise, if you're not stipulating to any of the evidence, then there's no plea.
Judge, we're willing to stipulate to everything except the final
Then you all
amount.
need to change your paper.
And Your Honor, I know to press a point on this, it's my understanding, my belief that the law allows us to not stipulate to true and correct. The judge has the evidence and the judge can look at that and decide that they find those documents credible and find that they are true or.
I can't do any of that if y'all are not stipulating to anything, then everything is a challenge. So this is what I will tell y'all to make it simple. I'm not accepting this plea.
Okay, we'll redo the paperwork. Would you
All right.
accept if we just simply put on that we do
Oh,
not
y'all
stipulate to the final amount?
Y'all do the paperwork. And if y'all want to put in there that the final amount from Berkshire and Visa is contested, which to me, you've already said that. That's why it's below the line. If y'all want to do that, fine. But everything else, no.
And you understand that all the money was for the junior league, but they just filed an insurance claim and a Visa claim.
Here's the
They're
thing,
third
I haven't
parties.
read any of the evidence, so I don't know what y'all are presenting because y'all haven't stipulated to anything. I don't know why there's an objection to outside the agreement. Everything that is outside your agreement is contested, and I'll hear evidence. This argument that you all are making on she doesn't owe to Berkshire, she doesn't owe to Visa, we haven't even got to that point yet because nobody stipulated to anything. And when things are below that line, that means that it's contested. That means I'll hear arguments. I'll hear whatever kind of law somebody wants to present me on whether or not you should be paying that under this cause number.
And Judge, the reason I am making this issue is because it says in the documents that higher amount, so we don't want to stipulate to that. So we'll change the document to say that and we'll reapproach.
Oh, y'all need to reprint that entire document out because that's been sworn to. She's been sworn to that specific document by the clerk. And if people start making changes to that document, it's no longer a sworn document.
We can do that, Judge.
Okay.
Thank you.
So yes, so everything needs to be reprinted and redone. Thank you.
Thank you.
All right, who's next? You all have put on here that you're contesting the total amount owed for restitution. You're not, because you all agreed that she owed the amount to the junior league. Am I right? So
Right.
that's not contested.
Right.
So
Judge,
if
I
you want
may?
to put that in there, you need to put specifically what you're contesting. If you're contesting the insurance company, then you should put the insurance company in there. Otherwise, you're saying you're contesting
Judge, may I
your league.
address? it?
Sure.
Because I'm the one doing this, not
Okay.
Chandler, so. Judge, what we're contesting is just the final total amount that are in the documents that are contained in State's Exhibit 1. And so that's what I'm trying to put on there, that we're contesting the total amount that they're saying is owed.
So you're contesting the amount that they're saying
We're
is
just
owed
saying
to
it's-
Berkshire Hathaway and Visa?
Yes, indirectly. I mean, in the documents, Judge, in the State's Exhibit, it has that she owes, that the total amount for the funds that were taken were 11,000 something, okay? We agreed to make a payment of the 1,077.01 upfront, but we we have never, and we don't want to in the paperwork to stipulate that the 11,000 number that's in the state's exhibit documents is a correct number. We believe it's lower. So that's the only issue, and Judge, and the reason why I want to have this in the paperwork is because if we're requesting that you not order a restitution hearing and let the third parties handle that on the civil side, where they can get accountants and they can really dig into that. And so if we stipulate to the true and correct nature of all of the state's exhibits, that includes that 11,000 number, and on the civil side, then there's nothing for them to, have accountants come in and
So this is what I'm telling you all. When you say you're not stipulating, you're stipulating to everything but the amount, you're including the amount to the junior league in that. If you want to put in there
okay, I can put in,
something that else to address that, you can put that in there. But when you all say you're not stipulating to any amount, then she's not even stipulating to the junior league amount.
okay. We can put in there to owe to third parties.
Well, the junior league is a third party.
Well, the junior league is the complainant. They're not a third party.
What I'm telling you is the parties are the
State of
state and the
Texas.
defense.
Right.
Well, your client, the state and your client. The junior league technically is a third party. So whatever is in there that you all are not stipulating to, which it appears to the court from your plea bargain agreement, the only thing you're not stipulating to is the amount to Berkshire and the amount to Visa.
Yes, Your Honor.
Is that correct?
Yes.
So
And
why
that's
is
below
it,
the line anyway.
so why is it hard to put in there? We are not stipulating to any amount owed to Berkshire or Visa. Why can't that be added if that's the total amount?
I can do that, Judge.
Okay. Thank you.
Thanks, Judge.
Do you want us to print this out again, or can I just change the language?
You'll have to write it in there and then have her re-sworn by the clerk. All right.
Yes.
All right. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
All right. According to the plea, the state is waiving count one, proceeding on the lesser included offense of theft, $750 to $2,500 under count two. They're recommending deferred adjudication. There's restitution of $1,777.01 to the Junior League of San Antonio through the DA's office, and that has been paid. Is that
That's
correct?
correct, Your Honor.
Did you understand that to be the plea?
Yes, Your Honor.
State,
That's right, Your Honor.
defense.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be restitution of Berkshire Hathaway in the amount of $9,799.42 and $227.71 to Visa. Did you understand those were recommendations from the state? And the court does not have to follow those recommendations.
Yes, Your Honor.
Then to the lesser included offense under count two, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Well, for exhibit one with all attachments.
Any objection?
No objections, Your Honor.
Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, the state would not be calling witnesses? Their evidence would be in the form of witnesses' statements, police reports, and bank records. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. All right, with regards to the amount that's outside your agreement, we'll come back for a hearing. And at that time, I'll sentence.
Okay.
All right, Ms. Ferguson, I need a reset date. And this is just for restitution.
And
Judge, are we gonna have a full restitution hearing? If so, we're going to have to get a forensic accountant, I'm not an accountant, to go through all of the documents and bank records to prepare for that hearing. Your Honor, I would respectfully request if you would not order restitution or not make a decision and not have a hearing and let them handle that on the civil side in the civil courts.
Yeah, I'm not gonna do that.
If I may respond briefly.
Yes.
Just the state's theory that that amount be assessed as restitution is that is an amount the defendant received the benefit of. She can't keep.
I'm sorry.
She can't keep that benefit.
Okay. All right, we'll set it for a restitution hearing. Norm, I need a reset date for a restitution hearing.
And Judge,
You're out 45 days.
just to make it clear, we're not requesting that she keep anything. We are requesting that we get to the correct amount.
Okay. All right, we'll be back on December 11th. Once you sign the reset form, you're excused, and on that date, I will sentence. All right, thank you. You're welcome.
You need anything else from me, Judge?
No, that's all.
Y'all have a great day.
And would be excused, Your Honor?
Yes, once she signs the reset form. All right, Mr. Evans, the state is tendering a dismissal. They're saying it's for missing witness, not for insufficient evidence. Do you understand?
Yes, Your Honor.
So I don't know what brought you here other than the charges that you have. But if there is some sort of issue that's going on with you, you need to correct it. Otherwise, you're going to be back in someone's criminal court. You understand?
Yes, Your Honor.
And Your Honor, I'm requesting if the court would make the dismissal with prejudice so that we could do an immediate expunction. There were issues with the stop, which we're talking about doing a motion to suppress on, but they decided to dismiss because they were not able to get the information subpoena that you ordered them to subpoena last setting. And I just want to make sure for my client that I can do an immediate expunction for him.
I am not going to grant a motion to dismiss with prejudice.
Okay, thank you, Judge.
You're welcome.
I just want to get my thoughts organized here.
Sure.
At our last hearing on this case,
Mhm.
You ordered the state to subpoena the information that was missing.
Mhm.
They did not subpoena the information that was missing. They didn't initially say, yeah, we're going to dismiss this case.
I'm sorry, just if you could hold on a moment, that's the printer is running and,
I understand. I
All
have
right.
that problem too.
all right, yes.
Maybe we should put this on the record.
Sure, you want to bring your client up?
Yes, Mitchell Evans.
Could I see the file on Mitchell Evans, please? Court is calling 2023 CR 6408 State versus Mitchell Evans. Can I have parties announced for the record for the state? For the defense?
Linda Corley for Mr. Evans.
And are you Mr. Evans?
Yes, Your Honor.
All right. So that the record is clear, the state tendered a dismissal, and that dismissal was based upon a missing witness. The court signed the dismissal, and the defense asked that the case be dismissed with prejudice so that her client's case could be expunged. The court denied the defense's motion to dismiss with prejudice. Defense, and there's something you wanted to put on the record?
Yes, Your Honor. I'm when last we were at court, the last hearing, Judge, you ordered the state to subpoena some missing discovery that we've been trying to get since, I believe, the court had noted on the record last fall, I think October or November. I'm not sure on that date. We came back to court today. The state had not subpoenaed the information. I also talked with the prosecutor and he was unwilling to dismiss the case. And
I'm sorry, could you repeat that last
he
thing?
was unwilling to dismiss the case, feeling that it was a case that might be good for a motion to suppress. However, he didn't feel that it should be dismissed. And after further consultation, I guess amongst themselves, they decided to go ahead and dismiss the case based on what was first marked as a further investigation, which I had issues with. And so it was, after discussion between the prosecutors, changed to missing witness. Judge,
what I don't want to have happen to my client is to have the prosecution do a workaround to give themselves more time to get information that would have otherwise probably been suppressed and then go forward with the case. That's my
State, are
concern.
you, on the record, are you planning to re-indict this case or refile this case? All right, so the state has no intention to refile this case.
Yes, and I.
Wait,
I'm
just a
sorry.
second. So state has no intention to refile this case? All right, you may proceed.
I'm sorry. And I am definitely not disparaging our prosecutor here. She has actually, as far as I know, she's reached out to China Grove multiple times and they have completely ignored her. But they did not issue a subpoena, and at the hearing, at the last hearing, we specified it was for the officer, that he would have the information about the call. So they did not subpoena. I guess, Judge, I'm just in an abundance of caution. I would like for you to rule on, I would ask that just in case anything happens, prosecutors change, I would like for that information that was to be subpoenaed, specifically the information about the call and the additional, all of that the officer put in his report, I would like for that to be suppressed, just so that in the event that something does happen, and this case does get refiled, they didn't get to do a workaround because they didn't follow the court's order.
All right, so what the court will say on the record is, as far as the court making a ruling on a motion to suppress, the court does not have a motion to suppress before it, so the court cannot suppress any evidence. I don't even know what the evidence is. The state has stated on the record that they have no intention of refiling this. I would think probably the best thing to do is to ask the court reporter to print off this record where the state said that they will not be refiling this.
And Your Honor, if I may?
Yes.
I'm not asking you to grant a motion to suppress that hasn't been heard. What I'm asking you is to suppress information that was not properly disclosed under 3914 in a reasonable amount of time, and that is an option that, and a resolution that has been used by courts before whenever information was not provided under 3914 properly, that information was suppressed as the remedy.
All right, so it is hard for the court to agree that some information should be suppressed when I have no idea what the information is. Sometimes the remedy is defense is allowed an opportunity to review the information, maybe call different witnesses if need be. But for the court to enter a suppression of evidence that the court hasn't seen, I'm not going to do that.
Your Honor, it's not information that's unknown. And I appreciate your patience with me, Your Honor.
No.
It's not information that's unknown. We know what it is. We know that the officer said that he received a call on his cell phone giving information about a car that was driving recklessly. And so we know what that is, but we don't know who the caller was. And so the order was to subpoena to get the information about the caller. So we know exactly what the information was, and they failed to get it. We've been trying to get it since last fall. And so that would be a violation under 3914 and a normal remedy for that, because the 3914 really doesn't have any teeth in it. The only remedy we have is then for the court to say, well, you can't use that information if it was to go forward. That information is suppressed. You can't use it because you didn't abide by 3914. And that's all I'm asking the court to do.
All right, anything from the state?
Judge, I've just gone in agreement. I've already stated that we follow the case, all the annotation in the system.
And again, Judge, this was just an abundance of caution to represent my client effectively.
No. I appreciate your arguments. The court is going to deny your motion. My suggestion is that you obtain a record from the court reporter. Cindy, if you'll make sure that she has a copy of this hearing, and you just need the portion where the state said that they would not be refiling this case. And then if need be, if you need to call me as a witness, I'll come as a witness if they refile it.
Thank you, Your Honor.
Without subpoena, well, I'll need a subpoena, but just know I will come and I will testify.
Thank you for your patience.
No problem. All right, you all have a good day.
So this is an MTR case, Judge, and,
Wait, I don't have the motion to revoke.
oh, do I? I'm sorry, there. You want that? You want the?
All right, so this is gonna have to come back at 1:30.
I mean, it's gonna be quick because I got, he's on an MTR and I have the complaint and I got the judgment that I provided to the state,
Okay, I'll have y'all come back at 1:30. Who's next?
1:30.
Who's next?
I can't come back at 1:30.
All right, James Francis. Court is called, please announce for the record.
Lauren Espinoza for the state.
Anita Perez for the defense.
And are you Michael Rivera? Yes. All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Michael Armando Rivera who's placed on community supervision in 2019 CR 5302 for the offense of possession with intent to deliver a controlled substance penalty group 1, 4 grams to 200 grams on December 3rd, 2019 for a term of 6 years? Is that you?
Yes.
All right, state.
Violated condition number 1, on or about the 5th day of September 2020 in Bexar County, Texas, the defendant, Michael Armando Rivera, committed the offense of possession of a controlled substance in violation of condition number 1.
How do you plead to that? True or not true?
State will waive the remaining.
Any objections to the waiver?
No, Judge.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion and sentence you up to 10 years in the prison? I'm sorry, yes?
Yes. Yes.
All right, knowing that, do you still wish to plead true to violation of condition number 1?
Yes.
Are you sure about what's going on here?
Yes.
All right, so you understand whatever agreement you have with the state, the court doesn't have to follow that agreement? All right, you're gonna need to speak up so the.
Yes.
All right, so do you understand if I find violation of condition number 1 true, that the court could sentence you up to 10 years in the prison?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 1?
I don't know what you mean about that.
All right, so do you think you have an agreement with the state on what's going to happen with this motion to revoke?
Yes.
I don't have to follow that agreement. You don't have an agreement with the court. Do you understand?
Yes.
So I can sentence you up to 10 years just based upon your plea of true to violation of condition number 1. Do you understand?
Yes.
Knowing all of that, do you still wish to plead true to violation of condition number 1?
Yes.
All right, the court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to grant state's motion to revoke and sentence to 10 years prison.
And is there this new number 1, what's happening with that?
That is my understanding that he was sentenced on that, and I believe defense has the specifics.
Okay, he's
Yeah.
been sentenced on that?
Right, I have I'll tender to the court and the clerks the judgment in the federal case. And I showed that to the state, and then this is the criminal complaint. And then I also have the docket summary from Pacer. And so if I can just put on the record the dates of incarceration.
But here's my question though. State, you don't have a possession of controlled substance that's been filed with your office?
No, Your Honor, that's based on the federal case.
All right, and you have no intention of filing?
No, Your Honor.
All right, yes.
Yeah, and so we're just asking, he's got, I think, 281 days in Bexar County Jail. And we're just asking for the court to acknowledge the dates that he was in federal prison. And from the documents that the court has before, it would be September the 5th, 2020, until he was booked to Bexar County, which is September 20th of 2025. And that, that's about 5 years, Judge. I think it's 5 years and 10 days, 14 days. So we're just asking for that credit as well, in addition to his Bexar County jail time.
All right.
And you want me to just hand it to the clerk?
Yes.
Okay. You want this?
All right, Are you asking the court to follow this agreement?
Yes,
Are you waiving your right to appeal?
yes,
All right, the court is going to grant the motion, revoke, sentence you to 10 years in the prison, give you credit for any time served. This will run concurrent with the SA 20 MJ 1083. There is to be no residing in households with minors. And no unsupervised contact with minors. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
yes,
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
yes.
All right, we can go off the record. You can speak with the clerks to make sure they have the correct calculations.
And I don't know if my client wants to say anything, but, anything you want to tell him?
I be here 5 years ago with the other lady. Everything went good. I saw my CDS paper. I know I did wrong. I lost a lot of my family, a lot of members. You know what I mean? I respect 187, you know what I mean? I like 187. But when I came the other day.
No. I mean, I guess with respect to
But
the
this with
plea agreement,
with the plea agreement,
you know, I mean, as far as.
yeah, you did good. You know what I mean?
No, but as far as, I guess, just wanting to move on with your life and
Yeah.
get this case over with, obviously you've already.
That's what I'm telling you. Look,
Yeah.
I've been in the field for 5 years, and I lost a lot of my family, and I promise to you in here, I don't want to sell drugs no more. That's not for me. I did a lot of classes, rehab, and the facilities over there. I did RDAF, 500 hours. I did behavior. I did all that, and I think I'm gonna put this behind. You're not gonna see me no more over here.
Okay.
I promise.
Well, I'm hoping that's the case, because really with these charges, at some point in time, the police are going to catch you. And then you're going to end up either in prison, the state prison, or either the federal prison. And the federal prison, it's a lot of time when they give it to you, but they give it to you in months. So you're just sitting there, 60 months or 80 months doesn't sound that bad. And then you would do the calculations. You're like, whoa, wait a minute. So this is what I can tell you. If you have not truly changed, and if you don't get your life on track, it's not going to end well. So now and what I can tell you is when you're released from custody, it's going to be hard. You know why it's going to be hard? Because people are going to see your history, and people are not going to want to give you a job. The best way to be employed is to have a trade or skill that somebody needs. And I was telling somebody before, I've had clients before who had major criminal history, and they're making major money legally. And you know how they did it? They went to trade school and they became a welder. Everybody needs a welder.
Let me tell you this real quick.
Mhm.
When I got this case, I know I make the bad decision to go to the Fed, but I chose somebody and then got me here and gave me this paper. But I mean, I'm not supposed to. I mean, he told me to take the box, and I did. You know, I did my mistake. I did my time, and it's time to do this one and go home and do me. That's
All
I was
right.
gonna say.
Well, just do better, okay?
Yeah.
All right. Good luck to you.
Thank you.
You're welcome.
Appreciate it.
You're welcome.
It was issued on January 10th of this year on US 131 there in Wayland Township. Said too fast for conditions involving an accident. You're hearing me, I'm on this citation to do one of three things. First is you could admit responsibility to the citation, or two, admit responsibility, but you'd like to provide some sort of explanation to court as to how or why this happened. Or three, you wish to contest this citation. In other words, fight this ticket at what we call informal hearing. What were you looking to do?
I want the hearing, please. I deny responsibility.
All right. Then the first thing I do is swear you both in. You want to go ahead and raise your right hands. You swear or affirm any testimony that you give here today would be the truth, the whole truth, and nothing but the truth.
Yes.
Yes, sir.
All right. Ma'am, it makes a lot more sense for me to start with the deputy. He has the burden to establish to me why you were issued a citation in the first place, but then after that, you'll have an opportunity to either ask questions or testify on your own behalf, all right?
Yes, can I just state something for the record first before we begin?
Sure.
The only thing that I wanted to state is that I did previously request an adjournment of this because I did suffer a head injury and I am written off from work because of my head injury by a concussion doctor at the neurology center at Bronson. I'm not supposed to be practicing law, so I don't feel that I should have to go forward. But I was told by the court we could not adjourn this unless I wanted to have a formal hearing and skip this process. So I
That
just,
is correct.
I
If you
wanted.
don't want to
court-
go forward today, you can ask for formal hearing. That'll get reset and they'd be compliant with you asking for a date considerably farther out. But for informal hearing, we don't move dates, either by officer or by defendant.
Yeah, I just wanted the court to be aware that my processing right now is slower. And so I might take a moment to ask questions and things.
That's fine. We have time.
Thank you.
All right. And so with that, Deputy, you want to pick up the narrative somewhere where it makes sense and explain the issuing of the citation?
Yes, sir. So on January 10th, 2025, shortly after 5:04 p.m., we were dispatched to southbound US 131, just south of the 6-1 mile marker on ramp, for one vehicle crashed into the ditch. Upon arriving on scene, we found a single vehicle identified as a 2016 Chevy, red in color, with the attached Michigan license plate of Edward Lincoln David 430, into the right-hand shoulder of southbound US 131. Through investigation, I found that the vehicle was traveling southbound when it had lost control, went into the ditch, and did sustain damage. I did issue the driver and the only occupant of the vehicle identified as Angelique, and I don't know if I'm pronouncing that right. Angelique Camfield Kuiper, the citation for the violation of the basic speed law for driving too fast. I did issue her citation SD 33604.
All right. And Ms. Camfield Kuiper, what is it you wish to tell me?
I would like to cross-examine the deputy, please.
Okay.
And Deputy Earl, how long have you been a deputy for the Allegan County Sheriff's Department?
I've been here for 2.5 years.
Any prior law enforcement experience?
Yes, ma'am. I've been a officer prior to that for a separate agency for a year and a half.
When did you graduate the academy?
I believe it was 2020.
And what,
Ms. Camfield Kuiper, how would this be relevant to your citation?
I think I have the right to ask him his background and experience to determine whether I was going too fast when there was no
Ma'am,
personal
let me-
observation.
Then let me just put something on record here. This is not a speeding ticket. It's not accusing you of speeding. You can get this ticket going 10 miles an hour. What it is you have a duty to maintain your vehicle on the roadway. Weather conditions and road conditions are not a legal defense to this ticket. Essentially, the only legal defense to this ticket is I didn't slide off the road. So I'll let you proceed, but what the officer's experience is not relevant. He's not making a judgment call that you were too fast for conditions. He's simply observing that your car left the roadway. That is the only element to this citation.
Actually, Your Honor, I looked up the statute and the statute says exactly, it is under the speeding statute under 257-627 parens 1 that I.
Yes, ma'am, but like I said, if you're going 10 miles an hour and you slide off the roadway, you will still get this citation. It is not accusing you of speeding. It is accusing you of going too fast for conditions. The prima facie evidence of that is that you left the roadway. But
Well,
you can
I
continue.
respectfully disagree with the court on that. Deputy, did you personally observe any of my driving that day?
No,
Did you speak to anybody who personally observed my driving that day?
no, ma'am.
Can you tell me what the weather conditions were that day?
I believe they were cloudy with snow.
Ron, can you tell me where you were when you were dispatched to the scene?
I believe I was in Wayland when I was dispatched to this scene.
Do you know what the distance was that you were away from where my car was?
I do not.
Do you know how long it took you to get there?
I do not.
Do you know if it was icy in addition to being snowy that day?
I do not recall.
Did you have an opportunity to review your accident report prior to testifying today?
Yes, ma'am.
Do you recall on your accident report that you wrote there was no ambulance at the scene?
I do not recall.
Would you refresh your recollection if you saw your accident report?
Yes, ma'am.
Do you have that with you, sir?
Yes, I can pull it up.
Could you take a look at that, please, and tell me whether you marked an ambulance was present or not?
Ma'am, can you tell me whether or not it would be relevant, whether or not there was an ambulance there?
Yes, Your Honor, if the deputy can't recall what the weather was, how long it took him to get there, whether it was icy in addition to snowing, and there are errors in the traffic report, it calls into question the veracity in his recollection with respect to that day.
Okay, but ma'am, the relevant sentence would be your testimony of whether, are you denying that you had an accident and left the roadway?
No, Your Honor, but I have
That's
other.
the only pertinent question.
I have other information to present to the court.
Okay, why don't we present it in the form of testimony as opposed to cross-examination, and I'll determine whether or not this line of inquiry is relevant to a civil infraction, ma'am. Let me put it another way. Road conditions and weather conditions are not a legal defense to this ticket. You have a ticket that says your car left the roadway. Do you have any information to present that your car didn't leave the roadway?
No, the statutory section says, did I operate at a careful and prudent speed, not greater than nor less than what's reasonable and proper, having due regard to the traffic surface width of the highway and any other condition existing.
I am infinitely familiar with the statute. Here's the issue. The testimony is that your car left the roadway. That is the prima facie evidence that you were not traveling at a speed conducive to the weather conditions and the road conditions. Ma'am, you can make that argument, but what I need to hear before I make a ruling, is we're getting way far afield of the information I need, is whether or not you had an accident where you left the roadway that day. And I have testimony that you did. If you would like to provide testimony that that didn't happen, that would be relevant for this citation.
So none of the road or weather conditions are relevant to this action?
No, ma'am. I sit here all winter, every year, getting this citation. If you have a slide off, even a one-car slide off, you will get this citation. We cannot give a ticket to the road for being icy or to the weather for being snowy. We live in Michigan.
But
people were driving all day long on 131 and not having accidents, but you had an accident. That's why you have this citation. The defense to this citation would be, I didn't have an accident.
Well, I don't.
You cannot blame it on the road or blame it on the weather. That is not an option for me to not find you responsible. I would still find you responsible regardless of the weather or regardless of the road conditions. You always theoretically could have been driving differently and not had an accident.
And the court is predisposed to a decision on these tickets.
Well, no, ma'am, because I would be willing to hear you say that didn't happen. I didn't slide off the road. But you're not suggesting that or testifying that. You just are going in circles about road conditions and weather conditions. So what I'm saying is I give you an opportunity right now to present to me relevant testimony to my decision of whether or not you had a slide off that day.
The relevant testimony, Your Honor, is that I was traveling at a careful and prudent speed. And
no, you weren't, ma'am. Otherwise, you wouldn't have had an accident. That is the definition of careful and prudent, right?
I disagree with the court.
Okay.
If I may specify, I would appreciate doing so.
Go ahead.
Thank you. I work in Grand Rapids and I live in Kalamazoo, Michigan, and I was on my way home from work. you'll have to forgive me, this, when I talk about this accident, it's very traumatic and it makes me extremely upset. Um, I haven't had a citation in over 20+ years. My last ticket was when I was in my 20s on my way to law
Hey,
school.
Ma'am, again, that's a relevancy issue. It would be unfair of me if I looked up your record and made decisions on this case based upon whether you did or did not have tickets. All I have to do is decide on January 10th of this year, around 5:04 PM, did you slide off a 131 or not? That's the only thing I have to decide. I already have evidence provided from the deputy that that did in fact happen. This is your opportunity to present evidence to me that it didn't happen.
Well, I was driving at a careful and prudent speed, which is part of the statute. And just that the fact that my car went off the roadway does not mean that I was not. There were 22 accidents between mine and the hospital the EMTs were taking me to. They told me that. And it wasn't that every single person was driving too fast for conditions. I had just driven. So when I left my office, it took me 20 minutes to clear off my car. I'm very, very careful to make sure that my lights aren't covered. There's no snow on my roof or anywhere else. My plate is visible. I'm very careful with that. And I had just driven through an accident. I don't have a clear recollection, but it was either just at the south end of the S curve or towards Caledonia. And I was being very cautious because I was trying to get home safely and have a weekend with my daughter because her sister was out of the state at a soccer tournament and I just wanted some time with her. And I remember that I texted over the Bluetooth, my staff at the office, and I said, be very careful, the roads are bad. And then I called my daughter over the Bluetooth and said, honey, I'm gonna be late because the roads are really, really bad and I just passed an accident and I'm taking my time.
Ma'am, I'm gonna caution you. Did you just testify that while you were driving, you texted?
Over the Bluetooth, it's the voice to text.
All right.
I do not hold my phone while I'm driving ever, and I always wear my seatbelt. So I let them know that I was gonna be later because I was taking my time and being cautious. When I got into Allegan County, the roads were worse and the visibility was lower. And I'm hesitant always to change lanes in that weather because in Allegan County in particular, the road commission's really bad at clearing the roads. I've driven in this state. I've lived in this state my whole life. I know how to drive in the winter and to be cautious. And I was hit on I-94 in 2021. I was
Ma'am, you are telling a very long and involved story that is irrelevant to the decision I have to make today.
I'm trying to explain what happened.
How is anything that you've told me so far going to explain whether or not you left the roadway or not?
Because it tells you how it happened. I was being careful.
No, it doesn't, ma'am. The
Driving.
fact that you were in an accident in the past on a different road has no bearing on what's happening here.
It does, because I was rear-ended and slammed into the vehicle in front of me and it caused me trauma. And there was somebody that was coming up really fast behind me, probably a truck, I can't remember. Because I get really nervous then when they're behind me so fast because I've already been hit. So I slowed even more. And wanted to check what my indicator on and checked my mirror to make sure it was clear. And I started to merge over so I would get out of that person's way. And then the slush was pretty deep. It was about maybe 3 or 4 inches of slush between the lanes, and it caught my tires. And there wasn't anything that I could do. I wasn't driving too fast. I was trying to slow down even more and get out of that person's way. I'm very careful on the road.
Anything further you wish to tell me, ma'am?
Just that I don't think a preponderance of the evidence demonstrates just because I was off the road that means I wasn't driving carefully and prudently. I was even informing people how bad it was and saying to be careful.
Okay, ma'am, so for purposes of informal hearing, I would find that the deputy has met their burden and that you are responsible on this citation. Now, because you had a contested hearing, you do have a right to say, I don't agree with what just happened there. I want to take this to formal hearing. Formal hearing is in front of the district court judges. It involves the prosecutor's office. But to get to formal hearing, you must do 2 things. First is you must ask for formal hearing within 7 days of today's date. That window of opportunity to contest this further closes after 7 days. And 2, you must come in and post a cash bond in the same amount as the fine to guarantee your appearance at formal hearing. Do you understand your rights on appeal?
Yes, I don't know how much the ticket is.
I can tell you that. It's either 110 or 135, depending on whether or not they put the accident on there. $135. So if you come in and post that as bond, and then request that formal hearing within 7 days, you'd get another bite at the apple. I will tell you the problem that formal hearing will also be that road conditions and weather conditions are not a legal defense to this ticket, but you're free to exercise your rights. But we're all set for what we need to do here today. I'm going to go ahead and release parties. Thank you.
Thank you.